Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle.
You have muted. Muted. You muted yourself. You have muted yourself. Muted. Your mic is muted.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors. Let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome back, and we are live on BW TV, brought to you by BWF Solicitors. Good afternoon to you if you just joined us. You're live with us on the Community and the Law. This afternoon, as I mentioned earlier on in our pre-introduction, we are going to look at employment. We're going to look at you as somebody that has been employed by an organization. Now, did you know that it is unlawful for an employer to deduct something from your wages without your permission? The question is going to be put to our resource person, Lawyer Charles Asma of BWF Solicitors. BWF Solicitors are located on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, North London, N15 4NP. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. You call them on 0208 493 7340. I say the number again, 0208 493 7340, or the emergency number 077 127 61884, 077 127 61884. Now today we have bits and pieces of information that would be updating you with. And we're looking at three major things. Now, the first is about vacancies that exist in various organizations and how we treat them. We'll also be looking at the care worker route and what employers would have to know and the things that are coming up. Lawyer Bernard Owusu will be giving us that update in a jiffy. Then again, I will also be questioning you as to what we would have learned for now. So let's get into the information right now, and that's brought to, as I said, brought to you by BWF Solicitors. Now, we're talking about the law protecting women. The law protects women against unfair treatment and dismissal because of their pregnancy. Now, if you are pregnant and you are in any organization and they're using that against you and say that, yeah, you are pregnant, so you can't do this job and won't pay you and all the other details. Now, listen to this. Under Section 99 of the Employment Rights Act of 1996 and Regulation 20 of the Maternity and Parental Leave, Regulation 1999, according to that, a dismissal of an employer will be automatically unfair where the reason or principal reason for the dismissal is connected to the employee's pregnancy. So if you are pregnant and your employer says that because you're pregnant, we can continue to keep you in employment, they are flouting the law. Now, this is from a case, Mrs. L. Herring versus J. Loverick and Son. That case is what we are basing our argument on. So we're saying that under Section 99 of the Employment Rights Act of 1996 and Regulation 20 of the Maternity and Parental Leave, etc., Regulation 1999, a dismissal of an employee will be automatically unfair where the reason or principal reason for the dismissal is connected to the person's pregnancy. So if you're pregnant, tell your employer, yes, you can't dismiss me. You can't discriminate against me because I'm pregnant. Listen, you need me strong and you need to support me here and there. And that's the first bit of information I want to provide you. Now, the second bit is about the care worker route, privilege and opportunity that exists. Now, I'm going to the desk of the senior partner of BWF Solicitors, lawyer Bernard Owusu, who will be taking us through your rights and the things that need to be considered, especially for those of you who have been given employment contracts, those who are given the employment contract, and what the expectation from the Home Office is. Now let's watch this.
Hello. Today's video is to bring an update on what we've noticed over the last couple of weeks in relation to requests for certificate of sponsorship and defined certificate of sponsorship for skilled migrant sponsorship. The skilled migrant route is the only route to bring someone from outside the United Kingdom to work in the UK under the sponsorship arrangement, or to apply for a migrant already in the UK to work with a licensed sponsor. Since August, the law has been changed to ensure that there is an emphasis on the genuineness of the vacancy and employment. Every sponsor will be aware that before you apply for your sponsorship license, there's a requirement for you to show that there is vacancy for your potential employees. The Home Office have now ensured that those people who have applied for defined certificate of sponsorship to bring people from outside and those who are applying for others to stay here to work are able to provide evidence of their availability of work. This is because over the last few months, there's been stories of people who have come here and have not been able to work because their employers have not been able to provide them with work. The Home Office, therefore, as part of their regulatory regime and in the light of the various reports in relation to unavailability of skilled work, are now cranking up on supervision and regulatory requirements. So what is the genuineness of vacancy? The genuineness of vacancy is that there is a vacancy which is ready and available for someone to come and work. This requires that the vacancy is not a sham, neither is it a vacancy which is just being created to bring someone from outside or apply for someone here. So what the Home Office is doing is that they are asking sponsors who wish to bring people from outside or apply for people here to provide evidence in the form of a contract or agreement between the sponsor and either the NHS or the local authority or a private person. They require the contract to specify the duration of the contract, how many people are required to work on the contract, what will be the pay under the contract, and the location and venue of where the contract will be discharged. Therefore, if you're a sponsor and you're applying for a defined certificate of sponsorship or a certificate of sponsorship for those who are here, it behoves on you to provide this evidence of availability of work. If you're not able to provide evidence of the availability of work in the form of a contract, it is very unlikely that your request for defined certificate of sponsorship or certificate of sponsorship will be provided. This comes under your duty of candor and your duty to respect the Home Office laws. Unfortunately, this is a requirement that is supposed to be provided before the application is provided. It's only required over the duration of your request, and usually they only give you 5 working days to provide the evidence. Our advice to sponsors who wish to bring people in is to ensure that there is a ready-made vacancy and work is available for the potential employee. We hope this video is helpful. Please follow us on YouTube, on Facebook, on Instagram, like and subscribe so that when we share videos, you will be notified.
Well, you heard from the senior partner himself, things you need to know as a sponsor adult social care to make sure that you do not fall foul of the law. And that was brought to you by courtesy of BWF Solicitors. The senior partner, BWF Solicitors, Uncle Ben, was on hand to provide us with that information. And with that, we go to the third bit of the things that I need you to know, and that's one of the nuggets we haven't for today. Remember, we're live on BWTV, and the program is The Community and the Law on this very Saturday, the 2nd of December 2023. Remember, we've entered a new month. We're in the last month of the year 2023, so things will be happening. We need to give you all the updates. We need to get you ready so we round up the year properly and enter into the new one. We're talking about genuine vacancy. Uncle Ben mentioned that in the previous video, that the vacancy should be genuine. He went on to explain what it is that we have to know and to do to prove that the vacancy is genuine. And we'll put that in a nugget, and I want you to have a look at that. Now listen, I told you that if you really want some of these things to be sent you to your WhatsApp, just let us know. Send us, add me on our WhatsApp number 07950 780 07950 780. Now, what is a genuine vacancy? Sponsors seeking to recruit workers via the skilled worker route must satisfy the Home Office that they can offer genuine employment that meets the relevant salary and skill of the route. This requires that the employer must have a vacancy ready and available before they can recruit a migrant for the role. Let me try and take that again. Now, sponsors seeking to recruit workers via the skilled worker route must satisfy the Home Office that they can offer genuine employment that meets the relevant salary and skills level of the route. This really requires that the employer must have a vacancy ready and available before they can recruit a migrant for the role. Listen, sponsors must not assign a certificate of sponsorship, that is COS, if it is a sham. Now, I am told that in this month of December, they're going to do their spot checks, visit organizations and check if they have the genuine vacancies, and also comply with all the set of rules that govern the skilled worker route, especially the healthcare route. So please, if you're a sponsor and you want to recruit workers via the skilled worker route, you must satisfy the Home Office that you can offer genuine employment. And that genuine employment, the criteria is that it must meet a relevant salary, it must meet a skill level of that particular route, and you must have a vacancy ready and available before you can recruit somebody onto the role. So take note of that. This is based on the Immigration Rules Appendix Skilled Worker SW 5.5. That's our second nugget for the day. Now, just before I take a break and bring on my resource person, Royal Charles Asma, let me give you a tease of what I'm going to use for my quiz this afternoon. So let's see what question I'll be asking you. Look at it very carefully, and when we come to that, I will ask you to give me the answers. Honesty Healthcare Limited is a care company providing services to the NHS and local authorities. They currently have no vacancy for new employees because they have not been successful with their bids for new contracts. Okay? Honesty Care Limited, however, recruited 10 employees from outside the UK for non-existent positions and issued a defined certificate of sponsorship, DCOS, to each of these employees. Now the question is this: what advice would you offer Honesty Healthcare Limited? Having seen the nugget, if we could look at that again before I read the questions. Let's look at the nugget again, and I'll read the questions. Okay. Sponsors seeking to recruit workers via the skilled worker route must satisfy the Home Office that they can offer genuine employment that meets the relevant salary and skill level of the route. This requires that the employer must have a vacancy ready and available before they can recruit a migrant for the role. Now, you have had this piece of information, and now the question is, what advice are we going to give to the organization that has recruited people, that is Honesty Healthcare Limited? Now, one, the position that they have recruited for is a sham because it is non-existent and therefore not a genuine vacancy. Number two, they can recruit employees, although there is no work, and put them on a waiting list. Is that correct? I don't know. Well, think of that. We'll be coming to that at the tail end of the program. Or three, they can recruit their employees and offer them to a recruitment agency. Now, consider the bit about the nugget I told you about and spoke to you about, and also look at the question: what will be your genuine advice to give Honesty Healthcare Limited? Keep that in mind. I'll be right back, and we'll be going into the discussion. Remember, this will be at the tail of the program for us to look into. So, invite others. Click on the link, like the page, share, and also invite others to join us live on BWTV. And the program is The Community and the Law. I'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208-493-7340 or our emergency line 07712-761-884. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Okay, welcome back and thank you for joining us. We're live on BWTV, BWF Solicitors, Facebook, YouTube, and all the social media platforms. Now, what I needed you to really do for me was that when you come on board, just share the page for us and also click the notification button so that anytime we put material and content on the various social media platforms, you will have the alert and go and watch it. There's a lot of vital information that BWF Solicitors, proud sponsors, put out. Now, earlier on, I gave you a short, it was just about 2.5 minutes of Bernard Owusu, Uncle Ben as we normally call him, giving us an insight into what genuine vacancy and the rest of it are. I will give you the benefit of having to listen to that again. Then we'll come to introduce our resource person, and we'll go to the topic now. My topic this afternoon is about your wages, your salaries, and the money you earn from work. Now, did you know that it is unlawful for an employer to deduct employees' wages without their permission? Did you know? Okay, now when you take your payslip, we'll be looking at that, but when you take your payslip, there are several deductions that come out ahead. Did you know about all of that? Can you challenge any of those deductions that come on there? The taxes, the NI, maybe your loan, and all the other bits. Do you have to challenge that? Lawyer Charles Asma will be explaining that. But let's go back to pick up that video where Lawyer Benousu told us about genuine vacancies. We'll be right back. Listen to this.
Hello. Today's video is to bring an update on what we've noticed over the last couple of weeks in relation to requests for certificate of sponsorship and defined certificate of sponsorship for skilled migrant sponsorship. The skilled migrant route is the only route to bring someone from outside the United Kingdom to work in the UK under the sponsorship arrangement, or to apply for a migrant already in the UK to work with a licensed sponsor. Since August, the law has been changed to ensure that there is an emphasis on the genuineness of the vacancy and employment. Every sponsor will be aware that before you apply for your sponsorship license, there's a requirement for you to show that there is vacancy for your potential employees. The Home Office have now ensured that those people who have applied for defined certificate of sponsorship to bring people from outside, and those who are applying for others to stay here to work, are able to provide evidence of the availability of work. This is because over the last few months, there's been stories of people who have come here and have not been able to work because their employers have not been able to provide them with work. The Home Office, therefore, as part of their regulatory regime and in the light of the various reports in relation to unavailability of skilled work, are now cranking up on supervision and regulatory requirements. So what is the genuineness of vacancy? The genuineness of vacancy is that there is a vacancy which is ready and available for someone to come and work. This requires that the vacancy is not a sham, neither is it a vacancy which is just being created to bring someone from outside or apply for someone here. So what the Home Office is doing is that they are asking sponsors who wish to bring people from outside or apply for people here to provide evidence in the form of a contract or agreement between the sponsor and either the NHS or the local authority or a private person. They require the contract to specify the duration of the contract, how many people are required to work on the contract, what will be the pay under the contract, and the location and venue of where the contract will be discharged. Therefore, if you're a sponsor and you're applying for a defined certificate of sponsorship or a certificate of sponsorship for those who are here, it behoves on you to provide this evidence of availability of work. If you're not able to provide evidence of the availability of work in the form of a contract, it is very unlikely that your request for defined certificate of sponsorship or certificate of sponsorship will be provided. This comes under your duty of candor and your duty to respect the Home Office laws. Unfortunately, this is a requirement that is supposed to be provided before the application is provided. It's only required over the duration of your request, and usually they only give you 5 working days to provide the evidence. Our advice to sponsors who wish to bring people in is to ensure that there is a ready-made vacancy and work is available for the potential employee. We hope this video is helpful. Please follow us on YouTube, on Facebook, on Instagram, like and subscribe so that when we share videos, you will be notified.
Well, thank you, Mr. Usu, once again for that insight. And the advice to all of you is to like the page, turn on the notification, and when we share any video, you will have it. Lawyer Charles Asma, as I said, is now ready for us. I know I've taken a bit more of his time to do all the bits and preparations that I had to do. So let me get us to look at what it is that we have to discuss this afternoon. I'm just talking about the fact that if you knew it was unlawful for an employer to deduct your money from your wages without your permission. So we'll be unpicking that. First of all, Lawyer Charles Asma, once again, good afternoon. Thank you for your patience and allowing me to do all the bits and pieces to get listeners and viewers to understand a bit. How are you doing, boss?
I'm very well. Good afternoon, Brakaku. How are you?
Yeah, good. I'm fine. I know once you're in there, let me first of all again apologize to our viewers that have been away for the past 2 weeks. But yeah, so listen, I have come out of hiding and I'm here to serve again. We spend so much time on there. So I will get us to look at the question I've posed straight away, that deduction of wage, things from people's wages and all that. But first of all, let me ask, when somebody works and at the end of the month, or the week, or the payment period, the person receives the salary, what is that entailing? What's included in the person's wages? Is it just for the number of hours that have been worked, or there are things that will come in there? Can you have an unpicking of that, please?
Thank you very much, viewers and listeners. And once again, we have come to you on this program to learn. And today's topic borders on employment rights as a worker or an employee. We are focusing on Section 13 of the Employment Rights Act, 1996. We are looking at subsection 1, 2, and 3. And the provision states that the employer must not deduct without permission or unlawfully from the wages of the employee. In other words, if you're an employer, you cannot deduct from the employee's wages without authorization or permission. And the wages will be as specified within the employment contract, and also any other form of earnings that the employee is required to be given within the terms of the employment. We will go through the list of wages under the law. And what it means is that the only time the employer can deduct, that's the exception, is when the employee has given permission for the employer to do so, or the law requires the employer to do so. So one of the laws that requires the employer to do such is to do with HMRC provisions. For example, tax. Under the PAYE provisions, the employers are supposed to deduct from the wages of the employee at source, that is directly, and give that to HMRC on behalf of that employee. And that is by law. So the employer has the right to deduct. The employer also is required by law to deduct national insurance. The employer is also required by law to deduct any pension arrangement. The employer is also required to deduct any agreement by way of share dealing or anything that the employee has agreed that should be deducted from my wages. It is also required by law that employer will deduct from the wages of the employee payment towards repaying student loan. If the employee took loan from student finance company to pursue learning or studies, then the employer will be required by law to make such deductions whenever the employee's salary goes beyond 21,000 for a year. So then that will call for deductions, and the employer will be notified to deduct at source from the wages of the employee. So those are the instances. Otherwise, the employer is not required by law to deduct such wages if there's no such agreement from the employee or there's no statutory requirement. And the agreement from the employee will stem from the terms and conditions, what we call particulars of terms of employment under provisions of the Employment Rights Act. You have your employment contract specifying your salary, specifying anything else that you have to pay, including if you have to pay pension, if you have to pay towards whatever that you have guaranteed to pay, then the employer will deduct to give to that agency or company that must be paid the money to, or that the money must be paid to. Yes, so those are the legal underpinnings with this or to this conversation. But your question was, what are some of the deductions? And so I'm going to take you through some of, or viewers through some of these deductions, some of these earnings or wages. So the wage, as we know, includes your actual salary for the year, and it's broken down into 12 months. So it's paid installmentally. It also includes fees, bonuses, commission, holiday pay, or other payment referable to the worker's employment. So any payment that is attributable to the employment of the worker is part of the wages accruing to that worker. So if you earn a commission or you earn a bonus and it's agreed and all that, that will go towards your wages. We're also looking at all the payments within the contracts between yourself and the employer. So if within the contract, the employer says that you'll be given a bonus that is expressed within the agreement or the contract, then it is part of your wages. We are looking at sick pay, statutory sick pay. The sick, as we know, the law requires that when you are sick, you have to show evidence of your sickness, which is what we call the medical certificate. And once you are off, if it's first 5 days, you don't have to have any certification. After that, you need certification. If you are on sick leave and you are going to be paid, that is part of your wages. We are also looking at adoption pay. It might be that there is adoption or statutory adoption program or process that you are pursuing. And as part of that, you are going to be absent for the purposes of the adoption process. Then you are going to be paid adoption pay, not sick pay, because you are not sick. Also, shared parental pay. So that's what we call shared parental pay, where both parents may share responsibility for the care of their children. And sometimes they can even, the law requires that if you are on holiday and yours is March, you can even trade it off against or with your spouse. All these things, anything accruing from that, it is part of your wages. For example, maternity or paternity leave, and if you're on leave, you have to be paid. Whatever it is that you are supposed to be paid is part of your wages. We are also looking at statutory guarantee payment. This statutory guarantee payment may not apply to all companies or all employers, and therefore it might not be common. But statutory guarantee payment will be things that are by law you are supposed to be paid, especially your basic wage. And we're also looking at payments when an employee is entitled a time off under the Employment Right Act. Example, time off to attend jury service, you have to be paid. All these things. So if, for example, the employer says that you've been off sick and I'm not going to pay you even the statutory sick pay, and therefore we are deducting that from your wages, then that will be classified as unauthorized deduction. That will be looking at. So anything that the employer is not supposed to deduct, and the employer deducts for whatever reason, without your consent, will be classed as unauthorized deduction. And that will trigger Section 13 provision of the Employment Right Act.
Okay, well, let me look at it from this point that I have applied to the organization, and I'm given an employment contract. Now it states that I will be giving a basic salary. There will be allowances, there will be bonuses, and all those things. Now, all these additions to the basic salary or wage that I'm going to get, if I have obligations under the law that they should deduct pension, national health, national insurance, and all the other bits. If I decide that I don't want to contribute to the work pension, for instance, can I state it at the point of signing the contract? Other than that, then it is as assumed that as a blanket rule, that pension has to be deducted. At the time of signing my contract, can I object to some of the things that are statutorily demanded that the employer deducts?
Thank you very much. There are pension provisions that requires opt-in or opt-out. So if you opt in, okay, so with pension, we have national insurance contribution. That is the base level of pension contribution. Because when you go on pension, whatever national insurance contribution you have made, in addition to the fact that when you were unemployed, you were supported through that, it's also the case that when you go on retirement, that is where you are going to feed from. So in this case, that is your basic pension, let me put it that way. However, there is high-level pension where the employer will make arrangements with a pension provider and put it in place for you. Let's call it private pension, but through the employer. Okay. In this case, it cannot be imposed on you. So you opt in or opt out. So from the outset, the employer will request your consent to be part of it. So once you opt out, then there cannot be any deduction. Once you opt in, then you are part of the scheme. So there will be deductions. If at any point in time you decide to opt out, you have to discuss with the employer, and that provider has to be aware because the paperwork has already been sent and it's started. So it's not a case of, I don't want to, and I'm not telling anybody. You have to seek approval in that case, not just the employer, but from that third party pension provider as well, or the fund manager as well.
Okay. Then again, you talked about levels for where deductions could be made. For instance, I have a student loan, and I look at my commitment, then I realize that if they deduct the student loan, I will be worse off. Can I ask for a deferment of that deduction? And can I object to that as well?
If there is any request to be made, you have to go to the creditor, which is Student Finance Company. Then, because
Okay.
Student Finance Company has authorized HMRC to work with employers to effect the deduction, the employer cannot say, because of your personal outgoings, we are not going to deduct. They will. So if there is anything to do, you have to then speak to the Student Finance Company or the lender, which once it's agreed between you and them, they have to notify HMRC. And HMRC will inform the employer with notice of deferral. That is only that when the employer will say that, right, we're not going to deduct. Otherwise, if the employer doesn't deduct, it will also be an infringement because the employer will be given notice of deduction. What the
Right.
person can do,
Yeah, go on.
what the person can do is to ensure that the threshold is below the requirement or the level that will call for deduction. We know that it's 21,000 and above. So if it's below 21,000, then there will be no deduction. Above 21,000, deduction will be on the difference.
Well, then can anybody lay a claim on my wages apart from the statutory ones? For instance, I owe an organization and the organization knows that I work with XYZ company. Can they lay a claim on there and ask my employer to make some direct deductions on their behalf?
Yes, that is by way of enforcement. So one of the means of enforcement is by what we call attachment of earnings order. So the court can order that you submit your breakdown and to show how much you earn. Then payment will be made directly as source to that creditor. So more or less, you are stubborn and you cannot be left alone, trusted to pay. So the employer will be notified with your permission based on attachment of earnings, then payment will be taken as source to that creditor. So it is a request through court to the employer that payment should be made at source, and the employer will have to effect that because it's an order.
So when it is that I am contesting any court decision, the employer would just have to wait for the final court order. Either than that, they can't do that, can they?
No, because there's no order at this stage that calls for attachment of earning, and the court will have to then specify how much needs to be deducted.
If you just joined us, we're having a discussion on our employment rights and the things we need to look at when we receive our wages. Does the employer have the right to make any deductions without your permission? The answer is simply no. But there are some statutory deductions that have to be made, and that's what lawyer Charles Asma has taken us through, and we're looking at all the other bits and pieces of that. You have your questions, you can text them to our studio number on WhatsApp is 0795042278, or text to our normal text number 0739920848, and the studio number to call in if you want to really ask lawyer Charles Asma any question. You call on 0208-493-7345, 0208-493-7345, and he will be glad to give you a very good answer that will help your situation. BWF Solicitors, we salute you and say thank you very much for your support. When it comes to the law, BWF Solicitors is our trusted partner. They know the law from A to Z, and they have a high success rate, as high as between 95 and 99% of the cases they present to court or applications they file for us. All of them are successful. They have over 30 years of experience behind them. The senior partner, BWF Solicitors and Ben, has practiced in the UK for over 30 years, and the experience is enormous. And they are so very generous to generate various ideas and strategies, and also tell us what to do when it comes to the law. So go to them for your immigration matters, go to them for your family matters, whether it's marriage and divorce, and all the other bits, employment, and anything that concerns the law, especially in the UK. BWF Solicitors is located on the 4th floor of the Honor House, 214-218 Tottenham High Road, Seven Sisters. Call them on 0208 493 7340. I say the number again, 0208 493 7340, or the emergency number 077 127 61884. Now, this afternoon we are with Lawyer Charles Asma, and when we come back in another discussion, I'll be giving you his direct number so you can contact him for all other details as well. BWF Solicitors are trusted partners when it comes to the law. We'll take a break, and when we come back, we will go on with our discussion as well.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340, or our emergency line 07712 761 884. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Okay, welcome back. Thank you very much for keeping faith with us. We're live on BWTV, and the program is The Community and the Law, brought to you by BWF Solicitors. Now, this afternoon, we're looking at the situation where deductions are made on your wage slip. What are the mandatory ones? What are the ones that you have not allowed? Just before we went to the break, I was asking the question whether anybody can lay claim on your wages and send that to your employer to deduct that for you. Now, Lawyer Charles Asma, as I said, is our resource person. Lawyer Charles Asma, let me ask again, based at the back of that question, so to speak. When somebody lays a claim, does my employer have to ask my permission before doing that?
Right. So ideally, you will know what's going on. If it is student finance, you will be aware that you have to pay student loan. So you will not be surprised if that comes off your wages. If it is court order that somebody is enforcing an order of payment, you'll be aware. But once the employer receives the notice, the employer may tell you that this is the case. They don't have to ask for your confirmation. They will just, or they may ask you or tell you that this is it, and just by way of courtesy. So let me say, they will remind you that this has been received and they are going to effect it. But whether they tell you or they don't tell you, whether they remind you or not, it's not the case. You will be aware anyway.
Okay, then let me go on to look at the situation again. Can bailiffs come to my workplace and ask that I make payments for them?
No. Well, bailiffs, they will usually come to your property, seize whatever items you have up to the value of the debt, and that's it.
All right. Then again, if, for instance, I join an association at work, let's say there's a labor union at work and there are dues to be paid, would that come off my wage slip? And if that is so, would they have to really get my permission to do that?
So in terms of union subscription, it's usually between you and the union. So you pay directly to them. If the union requests that you make the payment through your wages or through your employer, they will give you a paper to give to your employer so that you are all aware that such deduction, like direct debit, will be coming out. But with such deductions, it's usually the case that it is done through your bank. Rarely will that be done through the employer.
No, I'm scratching my head. I'm expecting a bonus at the end of the year. For instance, in December, people get a lot of bonuses. Can I insist that no deduction is made off my bonus?
Well, it's not a matter of you insist. It's a must that the employer must not um, withhold that bonus. So if it's a case that whether agreed expressly or agreed by other means, the employer is going to pay you bonus, that bonus will come. And what we are saying is that if the employer withholds the bonus, then there should be a reason. If it is not there completely, there should be a reason. But the case that, for example, the bonus is supposed to be X amount, and percentage of it is deducted for whatever reason, then that would be unauthorized deduction.
Right. Well, if you just joined us, as I said, you can call us on 0739920848 or the studio number 0208493745, or you can send a WhatsApp message to 07950422780. 07950422780. Lawyer Charles Asma is with us in the studio and is ready to answer all your questions. If you have any question, please let us know. We're talking about employment rights, and the question I'll be posing at the end of the whole thing is about your employment situation and the rest of the vacancies and the statutory ones. So maybe Prof. Ade, you would want to put a nugget back on there, so I'll remind people as to what it is that we have to look at. Now it says, what is a genuine vacancy? A genuine vacancy is a sponsor seeking to recruit workers via the skilled worker route. They must satisfy the Home Office that they can offer genuine employment that meets the relevant salary and skill level of the route. This requires that the employer must have a vacancy ready and available before they can recruit a migrant to the role. Now, the question I'll be posing later on is the one on the screen. Now, let's get to the question. And it says that, can we get a question? Um, there's this Honesty Healthcare organization agency that is providing services to the NHS and local authorities. They are currently not having any vacancies for new employees because they have not been successful with their bid for new contracts. Honesty Care Limited, however, recruited 10 employees from outside the UK for non-existent positions and issued a defined certificate of sponsorship to each of the employees. What advice would you offer Honesty Healthcare Limited? Would you tell them that the position they have recruited for is a sham because it's non-existent and therefore not a genuine one? Would you tell them that they can recruit employees although there's no work and put them on a waiting list? Then again, can you also tell them that, or is it right to tell them that they can recruit the employees and offer them to a recruitment agency? That'll be coming up later on. But in the meantime, if you have any question or concern, you can put that in the chat. We'll pick that one up and look at that and address that with Lawyer Charles Asma. If not, you can also text us and or call 0208 493 7345. 0208 493 7345 live on the community and the law on BWTV and BWF Solicitors, all the social media platforms. Let's take another break and I'll come back to ask Lawyer Charles Asma further questions before yours will come in.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome back, and thank you for your time. Thank you for your patience. We just said thank you to BWF Solicitors. As mentioned, my guest in the studio is lawyer Charles Asma. Lawyer Charles Asma, let's look at the situation again. Is there any further clarification you want to put on what the deductions are, what we can challenge, and what not?
Yeah, thank you very much, Brakoku. Yes, so viewers and listeners, let's have this practical session at this point. Then we look at what remedy we have in law once we've identified that there has been unlawful deduction or unauthorized deduction. So you have received your pay slip for or your wage report for the week or the 2 weeks or the month, depending on how you are paid or frequency of your payment. On that, you have your earnings side and you have the deductions side. So you have your basic salary, you have your overtime, you have your bonus, if any, you have fees and commission, if any, and so on and so forth, as agreed contractually or outside the contract with the employer. We now look at the deductions, statutory deductions, any other deduction. So statutory deduction, we have your tax, we have your NI, you have pension, you have student finance, if any, you have court order deductions, if any, and you may also have child maintenance deductions, if any, and any other deduction that is agreed between you and the employer. Let's take it that your salary, because the law says that the difference between your actual wage and what is actually given to you is the shortfall. That shortfall, we have to ask whether it is lawful or unlawful, because the shortfall means that the employer has it. If the employer has it, is it lawful that the employer has it, or it's unlawful? So let's assume that your wage is £1,000. All the deductions put together come to, let's say, £250, and you are supposed to be given a net of £750. The question is, the £250 deduction, is it lawful? Are all those deductions authorized or lawful? So we have to go through the checklist. Now we see that the person was absent, sick leave, for example, and that sick leave is statutory or must be given. Or let's say the person was off for 5 days with no need for certification. They don't need doctor's note to confirm that they were sick because they have to treat themselves. So first 5 days, you don't need to provide any certification or doctor's report. So you are away 5 days, you come back, sick leave, but the employer is aware. And you go to the deduction side and you see absence from work, and they calculate and they have deducted. That is going to be unlawful, because if I'm absent from work for 5 days, it does not trigger statutory payment where my actual salary may go down because of the statutory sick. This one, I am sick, but there's no need for certification. So I am as right as before, and therefore I should receive my full salary without consideration of that. So if the employer has deducted that you were not present at work or you were absent, and so this is deducted, and it is absence from work, then automatically you know that this is not right. So let's assume that this person, our scenario or case study individual, employee or worker, has had £100 deducted. What should the person do? Could be more than £100, could be less than £100. But the point is that if it is not authorized, the employer should not have deducted. So the person will have to notify the employer, because there are instances where the employer will be right to have that happening. And that instance is arithmetical error cases. So if there is error with the payroll process, then it's obvious that it is a human error. That error will be reversed, and the next payment, you get your money back. That's fine. But where the employer is pensioned on the fact that this must be deducted, and so is deducted, and you know that that is unlawful or unauthorized, then that will trigger the actions you can take. So you notify the employer insists. You inform ACAS. ACAS looks into it for you. Employer insists. ACAS will tell you you can take action. So the action you can take is that within 3 months from the date of that deduction, you can go to employment tribunal. And the claim will be unauthorized deduction from wages under Section 13 of the Employment Rights Act. You are asking the court to make a declaration that there has been unauthorized deduction. Then you ask the court to make an order for the money to be repaid or reinstated. And if there is a loss, compensation. Excuse me. Yes.
Situations when you report to us, for instance, or you make that assistance to the manager, the accountant, or whoever, and they have to do something. Does it have to be one immediate into your next pay pocket, or they may decide not to do it? And if they don't do it, are you entitled to any compensation at all?
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Well, we had to do a quick intervention there. Lawyer Justice Ma is our resource person. We're doing this courtesy of BWF Solicitors, our trusted partners when it comes to the law. Located on the 4th floor of the Hannah House, 214-218 Tottenham High Road. Last one, I was asking this question just before we took that quick break. Now, if I realize that some deductions have been made on my wage slip, can I ask for compensation?
Yes, that is an order to be made by the court for compensation, provided as a result of withholding that or making that deduction, you have suffered financial loss.
Okay. Well, folks, if you have any question to pose, as I put the numbers on the screen, you can text us on 0739920848 or send a WhatsApp to 07950422780. If you want to really speak to lawyer Charles Asma as well, you can call us in the studio on 0208-493-7345. 0208-493-7345. Last one, I've got a few of the questions here via WhatsApp, and let me pick this very first one. It says, can parents who are legally living in the UK and have a child who was born here and is 7+ years apply to normalize the child's stay in any way? Parents who are illegally living in the UK and have a child who was born in the UK and is over 7 years, can they apply to normalize the child's stay in any way?
So to normalize the child stay in the UK or in Europe?
In the UK.
In the UK, yes. All right, yes. So it is very, very, very possible. So what you do is that you are not just doing it for the child, you're also doing it for yourself, having been illegal for the past 7 years. Now that the child is 7 years, the child has become a qualifying child under Section 117D of the relevant statute. Then the child application can be made for indefinite leave to remain. So you make application for the child indefinite leave to remain, and you also make an application for yourself as a parent of a qualifying child. Even though the child has no leave, the child has lived in the UK and therefore has private life in the UK, and the child is as good as any child who is a British citizen or has settled status. And so, yes, it's possible
to do that. Okay. I'll take the next question. It says, my friend did an application under the EU scheme but was refused. They have done the appeal, but he can't generate his share code again. Do you know what the reason may be why he can't generate the share code?
Okay, so I suppose the person is worried about job, because that's the only, if the share code is not coming, it means there's nothing to evidence. That's why it's not showing. But if the thing is refused, then there's nothing there. You don't have right. But your right will continue because at the time you made the application, you had leave. The person did not explain whether they had leave when they made the application. If they didn't have leave when they made the application, then the share code will not produce anything and it will show anything. Usually, it will show on the system that appeal is pending. But if it is to do with your job, your right to work, which I'm sure it is, then you tell the employer to carry out employer checking service if you are not getting your share code. Employer looks into that, makes the application. It will be either positive outcome or negative outcome. If it's positive outcome, it means you can go ahead and work with the same employer, not changing employer. So those are the instances. But as to why it's not showing, I suppose because there's nothing there to show.
Okay. The next one says that he applied for the indefinite leave to remain in July this year. How long would it take for the application to be resolved? And by what means will the UKVI notify them of the decision?
All right, let me start from the bottom. So they will
Okay.
notify you through the email address you provided when you made the application. How long? The standard is 6 months. At the moment, it can take even 9 months. So if you did it in June or July, then you are not there yet in terms of 6 months. So after 6 months, if it's not still in, you can contact them for an update. But they may come back to say that there is too many work or too many applications to be dealt with. So yours is in the queue.
Okay. Now, this next one is a bit of a long one. I'll try to summarize it for the sake of our time and space on the screen. Um, the son applied for a visit visa to the UK, but the visa was refused. Now, the grounds for refusal stated that as part of your application, you provided a statement from a particular bank in Ghana. Checks they carried confirmed that the statement was not genuine. And the caseworker is saying that um, the caseworker is satisfied that the person made false representation. Now, the person goes on to say that the truth is that the assertion and reasoning which forms the basis of the grounds for refusal is completely false. And the following point, the bank statement that the person submitted as part of the thing was the personal statement from a different bank, which is completely different from the one they have stated in the refusal letter. And he also says that he submitted only one bank statement as part of the application, which was a bank statement from the bank that he knows, not the one that is stated in the reasoning. The one he applied with is a genuine bank statement and a true reflection of the financial records. He personally obtained the bank statement from the bank and personally uploaded the statement during the application. Although the grounds for refusal is clearly based on a false claim by the visa office, which does not reflect the personal circumstances or any representation that are made as part of the application. They have stated that it does not have a right of appeal nor right to administrative review. Question they're asking is there any way that we could guide him as to the correct process so he could take steps to remedy the mistake that he claims the Home Office or the visa officer has made?
All right. So this was a question that was posted. So we can't probe this from the questioner, but I'm sure the questioner may be listening. So I'll ask these follow-up questions. We have to know, but at the moment we don't know, whether the person has been banned as well. If the person is not banned, then it's a normal refusal for visit visas. So you can only try again the next time. If the person is banned, that is where the question that he's posed or she's posed will come in. Because only when you are banned that you get worried and you want to know what to do to remedy the situation. Because once it's a case of false representation or false document, there will be a ban under Part 9 of the immigration rules, and specifically paragraph 9.7.2, which is the mandatory grounds for refusal because there is use of false document with the view to gain immigration advantage or take immigration advantage of the immigration rules.
Okay.
It is an allegation of deception, and therefore you have to prove that what they are saying is not true. You have to clear yourself. Because if it's a ban, then it's likely that it would have been banned for 10 years. I'm sure there is, but if there is no ban, then you don't have to worry. Apply again. But if there is a ban, then this is what you can do. There's no right of appeal. There's no right to administrative review under the rules for visas. So unfortunately, you are limited, but you have to take the bold step and say that even though I don't have this right, I have to clear myself. You can go for judicial review, and the court will look into it, provided you have evidence proving otherwise, that what they are saying is not true. If it is proven in court that it is the case, that what they are saying is not true, then the refusal will be changed. Particularly, you are saying that, I don't know whether there was actually any of the document that is false. But if none of the document is false, then they have to reverse the decision. But if one is false, but it's a case that you didn't use deception to get it, then that's a different conversation. So we need a little more information to be
Well,
able to give
the person has added that he's been banned for 5 years.
5 or 10 years.
It says up to 5 years.
Banned for up to 5 years. Usually
Yes,
they
that's
ban for
information
10
is
years,
provided.
but whether 5 or 10 years, the person has been banned. So he has to look into it and see how he can challenge that in court. And that will be through judicial review.
Okay. Right. There's another question here that borders on skilled worker route. I want to switch to another company as a skilled worker. What do I do?
If you want to move to another company, you go through the same process that you went through to get the first company, so that you get a new COS, then you use it to make a new application. So whatever you have done before, you have to repeat it once you have a new company or you have identified a new company.
Right. Now, there's this scenario. Maybe you can address that for us. There's this person that had completed their education, and they have 2 years post-study period to be able to find work. The person is going to pick up a certificate of sponsorship. Now the person wants to go back to that 2 year post-study uh, 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 that facility. Is that possible?
So they took the post-study 2 years. First,
Yes.
they took it
They took it, yes.
and
But
threw it
switch on to
away
a course,
and
certificate of
changed it
sponsorship.
to, or threw it away and took another,
Yes.
and want to throw this other and go for it again.
Yeah, I want to pick up that again. Does that facility still exist?
Remember they had the leave and they switched.
Yes.
So post-study is actually done once. That leave application is done once.
Okay.
So if you've done it already, why will you be doing it again? That's the legal point, because you have to do it once. It's a one-off right.
So that opportunity is gone.
No, the opportunity is already used.
Okay. No, so in this situation, the option that may be available to this person may be that to switch from one company to or the other. But the reason the person is giving that there's no job.
Well, if there's no job, that was the conversation from the senior partner, that we
Yeah.
all have to be careful. So if the employers are not proving that they have job, then we, the employees, must be careful, because we become innocent victims of circumstance. So
Okay.
that is a general advice. But suffice to say that, yes, you have found yourself in this situation. You either stay till you find a new one, or you have to be careful that the moment you jump, you don't fall into a pit that you will struggle to come to the surface. I would just put it like that. So before you do anything, make sure that you are not jeopardizing your leave, the existing leave. Find a new company. If you find a new one, you switch again.
Again.
Or if you have a
Okay.
child whilst in the UK and the child is a British child, you can switch to Appendix FM. So those are the instances. Or if you are not married, but you marry and your partner is on the skilled worker, then you can go under your partner as a dependent of a skilled worker.
Okay. All right. Well, the next one here says, please, sir, we applied for fee waiver before our biometric card expired, and it's almost 3 months, and still have not received a code yet. Can I leave my job and join a new company?
No. If the visa is already expired, you cannot join a new company unless the company is willing to employ you without asking for your right to work.
Yeah, but this person is saying that they applied for the fee waiver before the card expired.
But the visa is now expired. If the visa is now
I don't
expired,
think
they
so.
can remain with the
I can imply from that. The person didn't state it, but I can
exactly.
imply from that it's expired.
So if the visa is expired now, they can remain with the existing employer. They cannot jump or move on. You must move on with something in your hand, but you stay with what you had in your hand.
Okay. Well, you can still text us on 07950422780. That's for WhatsApp. 07950422780, or text 07399208468. You can also call us if you want to on 0208 493 7345. 0208 493 7345. Lawyer Charles Asma is here and answering your questions. Uh, the ones that you've brought in is answering all of that. Now, if you want to call Lawyer Charles Asma, just call him on 07947 636037. 07947 Okay. Another person is just text me about the same question we asked a moment ago, so we'll skip that. Um, Lawyer, I have been receiving a text message from a bailiff or a collection agency. Meanwhile, what they are pursuing me is a debt I have settled. What do I do to get them to stop disturbing me?
Okay, call them and tell them that you have already paid the money to the original creditor.
Okay. Now, let me look at it from this angle, if you would allow me. If I owe company A, and at a point in time they give it to debt collectors or to bailiffs, do I have to pay the bailiffs, or I can go back to the original creditor and pay?
You have to deal with the agent now. They will
Okay.
tell you that you had a chance to deal with us and you didn't. So now deal with our agent, the collecting agent. You see, what normally happens is this. The collecting agent might have bought the debt. We call it debt factoring. So once they buy the debt, they will pay the original company maybe 50% of it and pursue you for the 100%. And that's the difference is their profit. So it's business for some of them. Some of them too, it is a statutory enforcement that the court has required that agent to pursue. Either way, you didn't pay when you needed to pay. And once the third party has stepped in, they would ask you to deal with them. So if you have, this person saying they have already paid to the creditor, the original creditor. So what they can do is to tell this third party collecting company that I have already paid, and this is my proof of payment, and this is the date I paid. If the date is after the enforcement process started, in any case, if it is after, the original creditor will not collect it because you won't even have a chance to talk to them. They will always tell you that talk to the agent because it is now with a collection department. So if this person has paid already, that means they were able to deal with the original creditor. So please tell the collecting agent that I have already paid. This is my proof of payment. It might have been a mix-up. Then they will deal with it.
Okay. Well, folks, we will be taking a quick message and come back to our quiz section. I've given you the question several times, so this time I'll just drop your answers, and let us know. Black Smart would explain what the answer is. Then we will round up with our discussion as to what deductions could be made on your payslip, and the ones you can challenge, the ones you cannot challenge. The program is the community, and the law will be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome back, and thank you for your time. Last month, a quick one before I go to the quiz. This one is saying that if a relationship began after 31st, no, it's supposed to be 30th of June because June has only 30 days. If a relationship began after 30th of June 2021 between the EU citizen and an undocumented person, can they still apply for EU settlement scheme now?
So relationship began after 2020. So the person was not
Yes.
a family member.
Okay.
So you cannot apply under Appendix EU.
Okay. Okay. I think it's a bit straightforward. Well, with your permission, let me quickly go to our quiz, and we look at the question again. So can we have the quiz back on and see what we have? The question this week we asked, was an interesting one on genuineness of a vacancy. Let me pick the one up here and we'll look at that. Honesty Healthcare Limited is a healthcare company providing services to the NHS and local authorities. They currently have no vacancy for new employees because they have not been successful with their bids for new contracts. Honesty Care Limited, however, recruited 10 employees from outside of the UK for non existent positions and issued a defined certificate of sponsorship, DCOS, to each of the employees. Now, with the information we have had, the knowledge we have shared, what advice would you offer Honesty Health Care Limited? One, the position they have recruited for is a sham because it is non existent and therefore not a genuine one. Two, they can recruit the employees, although there is no work, and put them on a waiting list. Or three, they can recruit the employees and offer them to a recruitment agency. Now, drop your answers. Let's see on the screen. What do you have? Is it one, two, or three? One says the position they have recruited for is a sham and because it is not existent and therefore not a genuine vacancy. They can recruit the employees, although there's no work, and put them on a waiting list. Then three, they can recruit the employees and offer them to a recruitment agency. Is it one, two, or three? Let's see your answers quickly. Who is giving us any answer? Let's see what you have. Is it one? Is it two? Or three? Three says they can recruit the employees and offer them to a recruitment agency. Two says they can recruit the employees, although there's no work, and put them on a waiting list. Then the first one is the position they have recruited to is a sham one because it is non-existent and therefore not a genuine vacancy. Now, if we go on to the nugget, maybe before I do that in a minute, go to the nugget. And I talked about what a genuine vacancy is, and we have watched that video I think 3 times where Uncle Ben, the senior partner, clearly explains what genuine vacancy is. Sponsors seeking to recruit workers via the skilled worker route must satisfy the Home Office that they can offer genuine employment that meets the relevant salary and skill level of the route. This requires that the employer must have a vacancy ready and available before they can recruit a migrant to the role. So back to the quiz, I'm asking, what is your answer? Is it one, two, or three? Right. Last one. For the sake of time, Sandra says it's number one. Okay. Thank you, Sandra. We've picked up one up. But let me go to Lawyer Asma and see what answer we'll have and the reason for the answer, Lawyer Asma.
All right. Thank you very much once again. So, under the provisions of Appendix Skilled Worker, it is not enough for you to hold a license. It is imperative that you have genuine vacancy for the employee. The employee must also ensure that there's genuine vacancy for them. It's always difficult for the employee to know that the job is not there if the employer has already issued a COS and a contract. But whether the employer knows and not telling you or doesn't know, it's not the point. The point is that if it is found out, they will conclude that you do not meet the genuine vacancy test. So this comes into fold. Genuine vacancy for license and genuine vacancy when you have COS and going for your visa. But in this case, we are told that the person recruited 10 employees from outside the UK for non-existent positions and issued COS to each of them. That means the COS is issued, so the employer has sailed through. The problem now is with the employee. What happens to their visa? Would they be issued with a visa? No, they will not be issued with a visa because if they will conclude that the job is not available. So the position they have recruited for is a sham, and because it is non-existent, there will be no genuine vacancy. So what then happens is that they will not be issued, the employee will not be issued with the visa if they carry out assessment and they find out that the employer does not have the vacancies. But the question is, if the employer doesn't have the vacancy, how come they were able to issue the COS? It means that they might have had the COS before the restrictions came into force. Because now, if you apply for COS, they will ask you to provide the hours you have before the COS will be granted. So it is not as before. But the answer to this is one.
The answer is one. The first position they have recruited for is a sham because it is non-existent and therefore not a genuine vacancy. So those of you who were kind of confused, that is what it is. And Lawyer Asma has really given an explanation as to why the answer is one. The decision maker must not have reasonable grounds to believe that the job the applicant is being sponsored to do A does not exist, or B is a sham, or C has been created mainly so the applicant can apply for entry clearance and permission to stay.
Yeah,
Well, that's
Brakoku.
that for our quiz. We'll be bringing you another
Yeah,
next week.
Brakoku.
But watch out for the nugget on Monday when it comes out, and that our next week's quiz will be based on that.
Brakoku.
And with that, I'll go back to Lawyer Charles Asma for him to give a summary of what we have discussed today, and we'll draw the curtains down for the program today. Lawyer Asma.
I was actually drawing attention, so thank you for that. I want to use the opportunity to um, inform the public, the unsuspecting public, because we are all unsuspecting members of the public, especially will be employees. Today we have touched on genuine vacancy and the fact that if the vacancy is not there, your visa will be refused. What if the COS is also not genuine? Is it possible? We have been receiving the decisions that have been refused and the individuals banned. And what the Home Office say is that the COS has been found to be the same COS that somebody else has used. How did that happen? Well, nobody knows. But for us, the indication is that we have to be very, very careful, have the eyes wide open and ears on the ground. If you're applying for a job, do your own checks. Make sure that the COS you are issued with is one that is genuine and only you have it. If you are not sure, then don't go through a long chain of agents. Otherwise, you have yourself to blame. Because what happens is that once it is found out that the COS is not genuine, you will be refused and you'll be banned for 10 years. And it will take you 10 years to come back to the UK if you are lucky, or it may cost money for you to seek admin review, judicial review to get out of that situation. So let's be mindful of that. So today we have touched up on unlawful deduction of wages by employers from the employee. How does that happen? The law says that if the money that is due the employee within the contract is less than money paid to the employee, if it is not arithmetic error or it is not any oversight, then it can only be unlawful deduction if it is found out that any money has been withheld from the employee's wages. So if the employee is to be given X, or let's say given £10 and is given £5, and that difference is not lawful or authorized, the employee can seek that to be repaid or reversed. What happens is that if that is not done, the employee can go to ACAS for them to help. If it's still not happening, employee within the law can seek redress from employment tribunal within 3 months of that deduction taking place. Once the person goes to court, the person is seeking an order from the court to make a declaration that the wage is unlawful. The person will also seek an order from the court to ask the employer to reinstate the withheld money. And the employee can also ask the court to make an order for compensation if there has been loss or there has been financial loss to the employee. So these are the instances. However, we have to be clear that such deduction is unlawful. Where we are not sure, we have to seek clarification from the employer. It might be oversight, and that can be rectified. If it is not, then it is within your right to seek remedy in law. Thank you for joining us.
And
Have a good weekend.
And thank you very much, Lawyer Charles Aswa, for your time and also the share of knowledge and also taking time to address our questions as well. And to everybody that's been out there and watched us, I thank you very much. Those who have shared, I congratulate you and I encourage you to continue to share. If you are new on the channel and you stayed with us up to this time, there's every reason for you to like the page. So like the page and click on the notification button so that anytime we put content on, you will be notified as well. We've been live on BWTV, we've been live on BWF Solicitors Facebook and YouTube and all the other social media platforms. On behalf of the production crew, I am referring to my studio manager, Professor Ade, Sheila Ankara, Padmo Dudu. Sheila, congratulations to you. It's your first wedding anniversary. Thank you very much. And to my nieces and nephew at Sheffield, I'm talking about Kiki, Mamiki, and Inkan. It's Mamiki's birthday today. Happy birthday to you, little girl and beautiful girl. Daddy and all the uncles, everybody, we love you so much. And to you out there, I say thank you very much for your time. My name is Ulrich Owusu-Frimpong. We'll be back again, same time next week, with another edition of The Community and the Law. Until then, good evening.